Say if talking about the landlord, let's say you're the landlord, you have a client says, I have a tenant that hasn't paid 2-3 months. I want to get him out of there. What rights do I have to get him out of there? Can I just hire security and kick him out?
Right. That's a very good question. And I hear that very often. And we go, no, no, no.
Yeah.
Yeah.
So why can't a landlord do that?
So there are actually procedures for lockout by a landlord. And I say this carefully.
Really?
Because
Wow.
let me repeat again. There is a process for a lockout for a landlord.
Yeah.
But you don't want to do it.
Oh,
And
interesting.
and yes, you can, but there are particular steps you have to follow. And I have won many a case on a writ of re-entry because the landlord didn't do it correctly. It is so distinct as to what needs to happen, what paper needs to be on the property door, what the content of that paper needs to be, where you have to put an address of where they're going to get the key back for the change of lock. So it really doesn't do anything for the landlord necessarily. It's also not as powerful as landlord thinks. Their powers are not as powerful as landlords automatically start thinking right away. We always have to, and I say always, but some of the phone calls we get, we have to sort of slow them down. We go, and a lot of the comments I get are, that's just not right. It's my property. They're not paying rent. So like, I feel that wholeheartedly. But our comment to them is always, we're a pretty conservative firm. I say, I would rather you take the default notice period, the petition period up to trial, that time frame, and do it right and get a proper judgment, than try to use some tool within the property code that I have many times pierced on the other side because it wasn't done appropriately.
Oh, I see. So for landlord, there's a process.
Yes.
And it's better to stick to that process because that's the surest way to the judgment that you want.
Right. Absolutely.